when a senior citizen make a settlement deed, what are the legal requirements required to cancel the settlement deed as per the Senior Citizenship Act? What is the latest judgment? What is the Supreme Court judgments stipulates for the cancellation of this settlement deed? An important judgment was delivered by our Honorable Supreme Court in Civil Appeal number 174 of 2021. This judgment was delivered on 6/12/2022 in a case Sudesh Chikara versus Ramti Devi and another. Let us see the contents and what the requirements mentioned in the judgment, which will be helpful in filing a settlement in petition for cancellation of the settlement deed. Ladies and gentlemen, I am Razia Ali. Let us see this topic in this video. Supposing a senior citizen make a settlement deed in favor of his sons, daughters or grandchildren, and the son or the daughter or the grandchildren, whoever receives the property, fails to maintain the senior citizens, the parents or grandparents. Under Section 23 of the Maintenance and Welfare of Parents and Senior Citizens Act 2027, the senior citizens can file a petition for the cancellation of the settlement deed. So not only the settlement deed, it can be a gift deed or it can be a release deed. So whenever a senior citizen gives any property through gift or settlement deed or release deed without receiving any consideration, and on a condition that the transferee, let it be a son or daughter or the grandchildren, should maintain the senior citizen, and if he fails to maintain the senior citizen, then under such circumstances, the senior citizens can file a petition for the cancellation of the settlement deed or the gift deed. So Section 27 of the Maintenance and Welfare of Parents and Senior Citizen Act stipulates that the property, where any senior citizen who after the commencement of the act has transferred by way of gift or otherwise his property, subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor, and such transferee refuses or fails to provide such amenities and physical needs, the said transfer of the property shall be deemed to have been made by fraud or coercion or under undue influence, and shall at the option of the transferor be declared void by the tribunal. This is what the Section 23 of the Senior Citizen Act says. So in order to cancel the settlement deed or the gift deed, all the conditions mentioned in this act has to be fulfilled, without which the court or the tribunal or the authorities or the appellate authorities cannot cancel the settlement deed just because of the blank petition. So in this judgment, the Supreme Court categorically says that all these conditions mentioned in the 23A of the Act has to be fulfilled, without which the court or the authorities or the tribunal cannot cancel the settlement deed, like what the judgment says. So what are the conditions? The first condition is that the senior citizen or the parent, after the commencement of act, has transferred the property by way of gift. So this is a condition. First condition is that the senior citizen has to transfer the property through gift or other document. So it can be a settlement deed, or it can be a gift deed, or it can be any other document. But this act, this such right of transfer or settlement has to be done after the commencement of this act. So as the act was passed in 2007, this particular section I will tell you I will prescribe in the description on the date of coming into force of this section. So it has to be such type of transfer ought to have been done after the commencement of this act, that to particular commencement of after the incorporation of this particular sections, after the enforcement of the date. And this section was, I think, actually amended. I will tell you the amended date and the implementation date. So the transfer ought to have been done after this amendment date. Okay, enforcement date. Secondly, there must be some conditions that the transferee shall provide the basic amenities and basic physical needs to the transfer. So in the settlement deed or in the gift deed, there must be a condition, and the condition ought to have been mentioned, and the condition ought to have been stipulated, through which the condition duty has been costed on the transferee or the beneficiary, son, daughter, grandson, to provide the basic amenities and basic physical needs to the senior citizens or to the transfer. So such condition ought to have been mentioned. Then third condition is that the transferee, namely the son or daughter, ought to have refused or ought to have failed. So refusal or ought to have the failure to provide such amenities and physical needs is also one of the another conditions stipulated under the Act. Once all these conditions is fulfilled and the transferee or the person who made the settlement deed or gift deed opted to file a petition before the concerned tribunal, then at the option of the transferee, the court shall declare that such deed is null and void, and it shall be deemed to have been made by fraud or coercion or under undue influence. So these are all the conditions. Once these conditions are fulfilled, the settlement deed shall be, or the gift deed shall be declared as null and void, and it shall be presumed that the deed has been made by fraud or coercion or under undue influence. So in order to cancel the settlement deed or a gift deed made by a senior citizen or by a parent to their sons or daughters, these conditions ought to have been fulfilled. If these conditions are not complied, if the condition is not stipulated in the settlement deed or gift deed, then the senior citizen cannot invoke this section 23. So the petition filed by senior citizen without without complying any of these conditions, then this petition is not maintainable and it will be rejected or dismissed. Supposing in the settlement deed or in the gift deed, the conditions, namely the transferee should maintain this transferor, or the transferee should provide the basic amenities and basic physical needs, was not mentioned in the document, then the senior citizen cannot file a petition under this section, and even if he files this petition will be rejected. This petition will not be maintainable as per the law. In all these circumstances, the remedy available to the senior citizen is you have to approach the civil court, and the civil court they can file a petition. He can file a suit, and he can file a suit for declaration to declare such a transfer made through settlement deed or gift deed is void. You may ask, what is the difference between the petition filed before this authority and in the civil court? The civil court, the procedure is a wholesome procedure. Here, if you file a petition, if these conditions are fulfilled, then the Act simply says that it shall be deemed to have been made by fraud, coercion, or undue influence. So once these conditions are fulfilled, Supposing in the settlement deed you have mentioned that you have to maintain, you have to give basic amenities and basic physical needs, and the beneficiary failed to do that, then it shall be presumed, it shall be deemed that such transfer has been made by fraud, coercion, or undue influence, and automatically it will be declared null and void. You need not prove fraud, or you need not prove coercion, and you need not prove undue influence. It was made under undue influence. You need not prove all those things. Just these two conditions, mentioning these conditions and failure to provide those amenities and basic needs, it itself is sufficient to presume that such document is made by fraud, coercion, and indifference, and on that basis the court or the tribunal will automatically cancel the gift deed or settlement deed. If such condition is not mentioned, then you will have to approach the civil court. If you approach the civil court, you can make any grounds. You can make any grounds which is stipulated in the Contract Act. There are voidable agreements, void contracts, voidable agreements, or as part of specific performance act. There are grounds. So there you can allege that this document is made by fraud, or this document is made by coercion, or this document is made by threat, or this document is made under undue influence, or I do not it was been committed. They have forced me to make any execute the document like that. You can make any grounds, but mere averments or mere allegation is not sufficient. When you approach the civil court, you will have to conduct a trial. You will have to prove all your case. You will have to pay court fees. It will take a long time. The civil court will decide whether any such fraud or coercion, undue influence, or any threat or any other intimidation has been done. If it is done, if everything is proved to the court beyond reasonable doubt, then the court will consider that case, and there is a possibility to declare the document is null and void, or voidable, or void, like that. But the problem is that the civil court, the case, it will take a long process. You have to prove the case. The burden of proof lies on the plaintiff to prove the case. So it will have to pay court fees, and it will also talk. The trial procedure is also a lengthy procedure. You will have to produce evidence, documents, everything. But in here, no such things are available. You can just produce a document, settlement deed, and the settlement deed you may say that this condition is stipulated. Now he is refusing. I have sent a letter like this, demanded the transferee to comply, to provide me the basic amenities and basic physical needs. He failed to do that. Then automatically that itself is sufficient. Then the court will presume that it is deemed to have been made by fraud and coercion and influence. On the basis the tribunal will cancel the settlement deed. This is the difference between the simple civil suit and the petition under this Senior Citizenship Act under Section 23. So, if you are a senior citizen, or if you are a parent, you wanted to make any settlement deed or gift deed, you just mention this condition as an abundant caution. Once you mention the condition, these conditions are demanding, stipulating a condition that the transferee should provide basic amenities and basic physical needs to you. Then, if he fails to do that, and if you do not comply, if you do not take care about you, if he fail to maintain you, or if he is betraying you, then you can invoke this Section 23 of the Senior Citizen Act and file a petition. That is the thing advisable to all persons, all senior citizens, or all parents who wanted to make any sort of settlement deed or gift deed to your parent, to your sons, daughters, or grandchildren. So whenever you want to go for a settlement deed or gift deed, just provide these conditions as stipulated in Section 23. That will help you in case of any eventuality, so that they will also take care about you, and you will also have a hold over the property. So I hope you understand the legal requirements, legal conditions stipulated under the Act, and the judgments mentioned in the conditions mentioned in the High Court judgment. So, ladies and gentlemen, you may watch my channels. I have two channels, Lasiak Sattam Arivom and Lasiak Law Tube. Razak Law Tube is an English channel. Razak Sattomarium is a Tamil channel. Knowledge is power. Legal knowledge will not only give you power, it will also strengthen you and give you personality. Personally develop you, help you to develop your personality. It will also give you a strength. So whenever you have any legal doubt, just click my channel. Just type Razak Sattomarium or Razak Law Tube in Google Chrome. My channel will open. There you can see a lot of playlists. Through that you can see a lot of videos, and you can watch the relevant videos and clear your doubts and enrich your knowledge. In addition to that, if you have any special doubt consultation, you may contact me. If time permits, I will give you online consultation and clarify your doubt, provided I have time. Thank you. Goodbye. Razak Ali.